And good afternoon, alienated parents, alienated grandparents, alienated children, professionals out there, doctors, lawyers, therapists, CAS, anybody out there listening today. This is a great podcast that Andy and I are going to share. We are in Canada. I am from Hamilton, Ontario. Andy is from the Sioux. And we have our guest, Vernon Beck, Canada Court Watch from Oakville, Ontario. Vernon is a repeated guest here with much knowledge needed for people that are going court process. And who knows better than what Vernon talks about is Andy Martens. Um, He's been here with me for 3 years. We've been dealing with this situation, helping millions worldwide. And we bring our guests on that are very knowledgeable and helpful. And today, Vernon Beck is here to focus on a presentation understanding, how parents can promote their pursuit of justice in the best interest of their children in the context of family separation. Welcome both Vernon and Andy. I am so grateful to have you both. Andy, you could say hello and introduce yourself and say anything that you need to put out there.
Hi, Mary. It's great to be here with you again. And we've
Thank
been
you.
doing these shows, the Andy Martin Show, Real Talk, Let's Talk. But I don't pretend, I know a lot about parental alienation, but I don't pretend to know more than your guest does. This guy knows a lot. But again, I'm going to keep mentioning this. It's a choice. You know exactly where you're going. I'm not buying it. I have a narcissist that's living next to me, one of my next door neighbors, and the best way to handle a narcissist is not to talk to them because you know whatever you say is going to be turned against you. If I say white, they'll say black. So why put yourself through the aggravation? And they attract people that are off the rock or off the cuff, like, wow, this is the best you can do. So these people attract other people that are even worse or just as bad. Your friend's sister, Mary, is a good example of that. What her sister, so you see it all over the place. And I'm not going to waste my breath talking to somebody who just doesn't get it and doesn't like me for whatever reason. So I look forward to the great show with Vernon and Mary. Our relationship is great. It's solid. If everybody had a relationship like you and I do doing these shows, the world would be a better place.
Absolutely, Andy. Thank you. Thank you for that. Vernon, welcome.
Okay, thank you, Mary, and thank you, Andy, for the opportunity to come on here today to certainly give some information that will help a number of your readers. I'm not here to specifically talk about alienation per se. I'm here to talk about some of the tips and mistakes that people make that lead up to alienation in many cases, but basically the mistakes that people make when they get into separation, getting into the family court system and what have you. I ran across a document that myself and some other advocates did a number of years ago, I think back in 2020. So I thought it'd be a good opportunity just to share this and what I'll go down. And the document's called Understanding How Parents Can Promote Their Pursuit of Justice and in the Best Interests of Their Children in the Context of Family Separation. As we know, court decisions, family law judges make decisions based on the best interests of the child. So people have to learn how to best get into the court system and be able to know what to do to move in that direction. So I'm going to share my screen to go through a document that, and I'll talk about it. And I'll basically touch on the various things, and if there's time at the end to take questions and answers. So I'm going to go over to my document Mary, and so if you're
You
able to
ready?
if you want to set my screen up there, make sure it comes on.
There you go, Vernon.
Okay, there it is there. That's the topic of it, understanding how parents can promote their pursuit of justice. So basically it starts off here. What are some of the common mistakes that people make? Well, the first mistake that people make is they fall prey to using the broken and adversarial family court system. Unfortunately, people who haven't experienced this before, the first thing they say or are told, oh, you got to go see a lawyer, you got to go to court, you got to go this. But basically, the system is broken. The family court system is broken. Some of the highest authorities in this country, including Supreme Court of Canada judges, have publicly stated the family court system in this country is broken. Plain and simple as that. So that's one of the first mistakes people go, is believing that they've got to go into that system. And there's an article out of Maclean's magazine. Okay, I think and that was on the front cover of Maclean's magazine. I think it says a lot about what the family court system is all about. Here is a picture of a gentleman. I personally assisted him many years ago. He's deceased now, but he had been screwed over. And here's his letter. This was a public letter that he sent out to, it's still on the internet. It's a public letter that he put together to all the lawyers in Canada, basically saying that he fought for justice. He fought to bring freedom and democracy to Canada, to the United States, basically to the Western world. They fought for these principles. And what he's seen is that the lawyers are literally destroying what him and his comrades fought to bring into our society today. So there's an actual letter from him. In 1999, I helped him in court back at that time. And believe it or not, this guy was one of the photographers for Queen Elizabeth at her wedding.
Wow.
Yeah, and he has a huge story. He showed me photographs that he took of the Queen when I was in his apartment in Toronto. Okay.
Wow. That must be incredible. The stories they had back then.
He's got quite a story at the time, but we won't get into that. But anyways, mistake number two, people get emotional, and of course, they easily get dragged into the system, and then they get dragged into the he said, she said scenario. So there's allegations made against one party, and then the first thing that the other side gets all pissed off, and then they want to go and counter with their allegations. Okay, and basically they become emotional, and they let their emotions take over, and they get into a fight. And of course, this is what the lawyers and the adversarial system loves. Get the parents fighting against each other and forgetting about what's in the best interests of the children. And of course, the mistake number three here, they go to lawyers, and people that do go to lawyers or professionals, they're uninformed and unorganized. So people walk in there, they don't have anything organized. They go in there, and they're so emotional. They're sitting there talking to a lawyer, telling the lawyer about their story. And meanwhile, the clock is just ticking away at $300 or $400 or $500 an hour. I think the current rates right now are between $400 and $500 an hour. But people go there and they start talking, and no documentation, just, what can you do to help me? And they walk away just having a little counseling session with their lawyer, and they've already spent $3,000. Okay.
Mm-hmm.
So the idea is that people, before they go to a lawyer, they need to learn to make the most effective use, if they do decide to go to a lawyer, to be prepared and organized before they go. One of the mistakes that they make is to take on an adversarial position against the other parent. So remember, although it's an adversarial court system, and this is what the lawyers do and what the system is designed to do to get one parent against the other, ultimately, courts are about, what are we going to do about the children? What are we going to do about ending conflict? This is what the courts are really about. But people get into these battles, and they take on an adversarial position against the other parent. Okay, and they can't get their emotions out of the way. And of course, that is going to a judge is going to view them in a poor light when they do that. Okay, another big mistake that people make. They believe what they're being told by lawyers and other family court related professions without questioning and understanding the information and advice given to them. Certainly over the 28 years I've been at this, I have talked to many people where they have been told, given information by lawyers, by psychologists, by counselors, children's aid society workers. They have actually been told information that's illegal. They have been told information that violates their rights. Okay. And a good example of that is that in Ontario, and again, a lot of the stuff I'm doing is going to be focused on the courts here in Canada. But in Ontario, Canada, everybody has the right in law to take in a recording device and to record their court hearing. Yet I have talked to so many people, they say, oh, the lawyers have told them that if they can't do it, and it's illegal. And there was one case at the, I remember up at the Brampton courthouse in Brampton, the police would actually search people. And if you happen to have a little recording device with you, even your phone, they would actually take and they would confiscate that before you could even walk into the court building. Total violation of your rights, total violation of the Courts of Justice Act here in Canada. Now, we did correct that a number of years ago, and things like that. A lot of people will, for instance, they used to go on the courtroom doors. They used to have these brass signs that would say, recording is not allowed. Again, complete lies on signage right at the entrance to the doors. That's in violation to the law. And in Ontario, Canada.
Let me say something. 19 years ago, the police at the doors took my recorder, took out my batteries and kept the batteries so I wouldn't place them back in.
Yeah, and so you know, the police committed a criminal act against you. You probably would have a lawsuit, okay, because they took your personal property. They searched you illegally, and they took possession. That's theft. You know,
even when it's in the courtroom, that's illegal when they're going through the conveyor belt.
No, you are perfectly allowed to take a recording device into the courtroom.
Wow.
Nobody can stop you. Nobody can stop you. Now, if you are a party, you have the right to actually put that recording device down and record it. And neither the judge or anyone else can say it's under the Courts of Justice Act, sections 136 2B. But again, you'll never see this mentioned. You know, I used to be a journalist, and I used to be able to go in and you know, actually record. I had a press card and I could go in and record. But if you're a party in Ontario, if you are a party to a hearing or a lawyer, you actually have the lawful right to audio record those hearings. Same thing happens today. We're using Zoom, and if you're in a court hearing, they put this video clip on there. It says, you know, recording's not allowed. But under the Courts of Justice Act, you are allowed to audio record. So you could actually, if you're on a Zoom call, you can put an audio recorder on the table and you can legally record that. And that's sections 136 2B of the Courts of Justice Act in Ontario. So these are just some of the things that when we get back to the point I was making here, mistake is that people believe what they're told. Okay. Another thing that's being told is that sometimes you'll go to the court for a court hearing, and you may take some supporters with you, and a court clerk may come out and said, "Oh no, they're not allowed to come in. Only the parties are allowed to come in." Again, an outright lie. So, but people view the court clerk's got a uniform on, got a badge on there. They're viewed as a person of authority. So people who don't know their rights then will sit out in the waiting room. But if you're in a court hearing, they are public. Anybody from the public can go in. But lawyers will try to keep people out of there. They'll say, oh, no, you can't bring your friends in. The court clerks will come out. The only person that can keep someone out of a court hearing is the judge.
Is the judge.
So yes. you can take your friends in there. And if the judge says, if a lawyer or someone says, Your Honor, there's a bunch of people here, the only person that can ask them to leave that courtroom is the judge. He has to make an order. He can't just, sometimes they'll say, oh, I would suggest that they leave. That's a tricky word that they sometimes will use. It might be a good idea if they leave because the other lawyer is uncomfortable. Well, courts are not about making people comfortable. There's a law, and they're supposed to be open and accountable. And unless that judge says, I am ordering them to leave, and actually makes it an order, people have the right to attend a public family court hearing. Okay. Now let's move on here. Okay, here's another mistake that quite often people do. When they do get a lawyer, the lawyer starts handling all the communication, the emails, the letters and that, and they never get copies of it. They're not kept in the loop. The lawyer keeps all the stuff there and just phones people up and says, oh, I got a letter, they're saying this, and we got to respond. And basically the lawyer becomes the gatekeeper of all the paperwork. Now, here's what happens. And it happens very often. After a while, people get to a point where they can't afford the lawyer anymore. They're running out of money. Mm-hmm. Okay. And so they go to their lawyer and they say, well, look, I'm getting broke. I don't have any more money left to pay you. And so can you give me, I need to self-represent or whatever. Can you give me my file? Quite often, many people will sit there. The lawyer will say, well, you still owe me another $5,000. We used your retainer and I've worked on a bill. You owe me $5,000. You can't not get your file until you pay up your account. That's another trick that lawyers will do. Not all, the honest ones won't do that. But when the documents that are in a lawyer's file are your documents. They do not belong to the lawyer. They are your documents. So if a lawyer actually hangs onto those documents and says you've got to pay for them, that's theft, okay? And if you owe a lawyer money, like any other creditor, that lawyer has the right to go to court or can go to a collection agency to collect that money. But a lawyer cannot hold on to your documents that are your property and say that you have to pay money. That's called extortion under the Criminal Code of Canada. But I've had many calls from people over the years. They're freaking out because I can't get my papers. I'm supposed to file stuff and the lawyer won't give it to me. So it's not the good lawyers that do that, but there are enough situations that I've heard over the years where lawyers do threaten and extort people in violation of the criminal code. It does go on.
Yeah. Even one's too many.
Yeah.
Unethical.
Another mistake that people when they get into court, whatever, people have to get their cases in written format. A lot of people think, well, we're going to go and talk and we're going to talk to the judge, whatever. No, when you go into court, the documents that you submit, they become public record. A judge's decision is supposed to be based on the documents that are in that file, generally. Okay, sure, a judge may consider some of the things that are said verbally in the court, but usually things that are said verbally in the court are supposed to be already written in the documents. Okay, because that's what a judge is supposed to make a decision on. So if there's going to be an appeal, the appeal court takes those documents, and that's where they're supposed to look at the judge's order and to say, does the judge's order comply with what the documents are? It's not what was said, but what was generally what the documents reflect. You could go and get transcripts, but again, they could cost hundreds or thousands of dollars to get transcripts. So written documents, well put together, and with a good presentation, outlining the issues. And there's a photo, people will walk into a lawyer's office with a whole bunch of paperwork like that and not realizing their lawyer is going to charge them $10,000, $15,000, $20,000 to go through their stuff. Mm. Whereas if you become good, there are ways to organize it and to sort it out and to put it in a very concise way. I tell people that if they go to court, a good affidavit that all that the judge needs to read, they should be able to get that under about 10 or 12 pages. It shouldn't take a judge any more than about 30 minutes to read a case and to get an understanding of the issues and to understand what the solutions are. Okay. Unfortunately, people get into this he said, she said, and before you know it, the judge is pissed off and he doesn't even want to look at the rest of the stuff. So if you are well organized and you know how to make a good presentation in the court, um, the judge should read the materials in your affidavit, and a lot of the stuff is going to be contained in appendixes for just for reference, but most of your case you should be able to get done in the first probably 12 pages within less than 30 minutes of a judge to read. Next mistake people make here is, again, they make poor presentations in court if matters do end up in court. So again, this is where people get in and they start talking. Their lawyers start talking, and then they get emotional, especially people who are self-represented. They start yapping away and talking away, and the judge just gets fed up and doesn't want to listen. I tell people who are representing themselves, I said, it should only take you about 5 minutes. Sometimes I'll make up a speech for people to present, and they just tell the judge, Your Honor, I'm not a lawyer, I'm not a very good orator, and all I need you is to read my documents, and if you haven't read them, take a recess, and then we'll review my documents. At that point, if you've got good documents, well organized, the judge should be able to read your affidavit in probably less than 30 minutes, come back in court, and all you have to do is go through a summary of your affidavit, and the judge will already have a good point. So people go in there and they just make poor presentations. I've had people tell me that, the lawyers sometimes do a lousy job. They get bullied by the other lawyer, and people will say, oh, my lawyer did a lousy job. He didn't say anything when the other lawyer spoke about this or spoke about that. So quite often, poor presentations in court. Personally, I believe that we don't even need to have live presentations in court, that basically reality, judges should be able to just sit in their offices and read documents, and if the documents are well put together, people shouldn't even need to go to court. But that's another story. Here's another thing that I've been finding recently, and I have some cases very recently. Because the courts are overburdened right now, lawyers are being encouraged to get their clients out of the family court process, and they're being encouraged to go into arbitration or mediation. And mediation, quite often the mediation they're being recommended is mediation with mandatory decision making. So what they're trying to do is they're trying to coerce people out of the court system, and they're using trickery sometimes. In a case conference or what have you, to get people to agree. And when they get the actual agreements that they signed, what they're doing is they're signing arbitration. And that once you sign an arbitration agreement, you have given up your rights to attend family court. And if you look at people who look at arbitration agreements, now I'm not saying that all arbitrators are bad, but I'll tell you some of the arbitration agreements that I have done detailed assessments of are so unaccountable. They're secretive. They violate people's rights. They violate the rights of children. They are the worst option for people to go. Arbitration in family court is not an option, except in extremely rare cases. And once you give up your rights to participate in arbitration, I have yet in my many years to run across somebody who could say that arbitration, they were very happy with it and it didn't cost them money. I had a recent case within the last month where $10,000 retainer up front, and it was estimated that arbitration would cost between the two parties $60,000 over the course of about 2 to 3 months.
Wow.
Okay. And if you look at the agreements, they are scary. Actually, they actually state you cannot get out of arbitration once you sign that agreement. You cannot even get out. And if you
Is that
can't
for
afford,
life? Is that for life, Vernon?
I wouldn't say for
Or
life,
just for the case?
but for the case, but even at the end, some of these, they actually say you can't get out. And if you can't pay, the contract is extended until you do pay.
Oh, so it could be for life.
Well, it could be. So basically, it prevents you from going back to court. Okay. So,
Wow.
and there are a lot of, so arbitration and so another trick that they do is they have parenting coordination. Now, I'm a parenting coordinator. I've been in the court and I have been appointed as a parenting coordinator. But some of these parenting coordinators, especially the professional ones, they're, charging $300, $400, $500 an hour. And same thing, you got these conditions. You can't get out. You can't even disclose your documents. You can't take them to court. Everything is in secret. So as soon as you get individuals making decisions that judges should do in a private and secretive process, you basically have violated everything that we have in our court system today, which is some transparency, some openness, and some accountability. That's why family courts are public for people to attend. It's so that we can see what's going on. Once you get into these systems, basically it's very bad. So my advice to people, arbitration as a general rule is extremely bad for families. Okay, it is not the place where family should be settled. I have one case right now where the mother's lawyer was threatening the father that if he did not sign the arbitration agreement, that they would take him to court to force him to sign it.
Wow.
Well, a judge, not even a judge, can order a parent to sign an arbitration agreement. Not even
Well,
a
that's
judge.
good to
Okay.
know.
Okay. Again, no judge can make an order that's going to violate your rights unless there's a good fundamental reason. And once you go to arbitration, you are giving up your fundamental right in this country to a fair hearing in the family court. So, anyways, well, for the sake of time, I'll keep moving on here. So, again, don't get bullied. Now, the next part of this document here will get into some of the tips that people can do. Okay, I'm sure there's many other things, mistakes that made, but again, for the sake of time, I'm only going to cover what this document have. Tips for parents. One of the first things that people should do, they need to get themselves educated about the court system, about family, about separation, about taking a parenting and family court educational program for separated parents. You need to learn. You need to educate yourself because it's going to teach you how to go through the system. It'll teach you how to present yourself well and to understand what's in the best interest of the children. I actually encourage parents that before you go to court, that one of the documents that you are going to include with your affidavit as an exhibit is going to be the educational materials that you have studied as part of a parenting educational program, that you've studied doing parenting plans, that you've studied the harm to children. So you should actually have a parenting resume that you take so the judge can look at you and say, hey, this parent is so interested in the children that this parent has actually taken the time, invested the time to get to attend a parenting education program, learned about parenting, learned about the harm to children, has learned how to do a parenting plan. So getting attending an education program is helpful, and certainly if you have a certificate from a program, whatever, that helps too, because some of the programs, they'll give you a certificate. Okay, everybody needs to understand and that achieving justice in the best interest of children does not require lawyers, judges, or the family court system at all. A lot of people think, oh, we got to go to court. We got to get a court order. This is a bunch of BS. This is a photo here of Justice Thomas Cromwell. I met him personally a number of years ago up in Carleton University up in Ottawa, and I spoke to him, and there is his quote, okay, that we spoke about as well when we were at a conference. His quote says, access to justice is when people have the resources, the skills, the knowledge, and the services to meaningful address their civil and family justice needs. Access to justice does not mention courts or lawyers. Okay, it's not about going to a courtroom. It's just a matter of getting services that they need to address their problem. This is a judge from the Supreme Court of Canada, highest court in the land. That is his quote. You do not need judges, you do not need lawyers, and you do not need courts. And a lot of people don't realize that. And for instance, if couples make a separation or a parenting plan, lawyers, quite often the lawyers will tell you, oh, you got to go to court. We have to make it into a court order. That's a bunch of BS. Any document that is, say, a separation agreement or a parenting plan, other than under a divorce, with a divorce, you've got to go and go to some extra work. But for most families, if you do a parenting plan and it's signed and witnessed and it's fair and it's been basically a good plan, it is legally binding as any court order. And one of the advantages of not making a parenting plan into a court order is that once it's made into a court order, every time you need to change it because the kids are getting older, you got to go back to court. Whereas a parenting plan that's been signed and witnessed can be changed, just signed and witnessed again, and it's just as legally binding, and you don't have to go to court. But lawyers will tell people all the time, oh, we got this parenting plan together, we're going to go and get it made into a court order. Yeah, there you go. You're spending hundreds of more dollars to get the lawyer to put it in, and it's not necessary. An agreement, a parenting plan between two parents, signed and witnessed, as long as it is fair, the terms are fair and just, is as legally binding as any court order. And if anybody wants to challenge me, by all means, they can contact me on that one. Okay. Again, tip number 3, get yourself educated about the adversarial system. There's certainly lots on Google. You can Google all kinds of find people destroyed, children destroyed. There's lots of videos, whatever. And again, here's a quote. This is the highest judge in the land in Canada. Okay.
What's his name?
Well, this is Beverly McLaughlin. Okay.
Beverly. Okay.
She was the Chief Justice of Canada, the highest judge in this land, in our country. Right there saying family courts need to be overhauled. They're broken. Here's Justice Cromwell again in a suit making a presentation, basically saying that spouses and their children are seriously damaged.
Mm-hmm.
These are two judges from the highest court in our country stating that it's damaged. Here's another one here, Ontario. Chief Justice Warren Winkler from Ontario. Now, he's not the Chief Justice now, but there he is. Desperately needs a overhaul. Okay. These are some of the top people in our justice system saying it's broken. It's harming children. Okay. And, everybody knows that the system is so broken, it's becoming the laughing stock of many people. And tragically, it's harming. These are comics that people are coming up. Artists are making drawings. Here's a picture of the judge at the back, the 2 lawyers, and here's looks to me like a mother in the middle here telling her what to do. Okay, everybody's making money, and this is what's going on. The judge is sound asleep back there, not even listening. So people are making jokes and comedies. There's hundreds of paintings and videos out there and drawings out there about our court system. It's become a public embarrassment to this country. Okay, if you want to be successful, focus on solutions to current and past issues. Get out of the past and stop fighting. So one of the basic things I tell people is, if you're going to go into court, show the judge, show whether the professionals, whether there's an assessor, Show that you are trying to put the past behind, whether there were serious mistakes made or not, that you've solved them, but your focus is moving forward in the best interest of the children. Stop the fighting and blaming about the past. The more you do it, the judges just sit back and they just say, here's somebody who can't get their head out of the past, and they can't move forward in the best interest of the child. Okay, learn how to make a fair and comprehensive separation or parenting plan. Again, the Association of Family and Conciliation Courts is one of the parenting plans that are freely available. You can go on the internet, AFCC. You can they have a model there. They have a template. People can learn how to do it. I know I use a template that's probably even better and more expanded than theirs, that we use with Family Conflict Services to help people. But again, ultimately, the courts and everybody's looking for solutions. If you have children, the parenting plan is what you want to show your solution for the children. Okay, and when you go to court and you have a parenting plan, or if you're dealing with an assessor, you're demonstrating that you've taken the time to learn and to put it together and you understand. Learn about the specific factors related to the best interest of the child. Okay, if you go, certainly, and again, in Canada, if you look under the Divorce Act and things, do a bit of searching, you'll find they have some key criteria. They talk about behavior of the parents. They talk about how long, stability. There's a number of factors. So yes, everybody needs to know what the best interest of the child is. There's a point down here by learning about some of the specific factors, such as, for instance, when a child custody and access, like I'm trained to do custody and access assessments, the idea is there's a number of things that we look for to determine what do we do when we do an assessment? What are the factors? You're looking at these things, parental behavior. You're looking at things, child-parent relationship interference. Some of these are listed in this next here, tip number 7, learn about some of the assessment tools. Some of them are listed right here. Okay, parenting time and decision making. Learn what's in an assessment. What are those factors? They call them parenting time and decision making assessments now. They used to be formally called custody and access assessments. Okay, you're looking at things such as child-parent relationship interference. All these things that a parent does. Deny access, deny the phone, which are some of the most common. Send bad emails, all kinds of stuff. There's a whole list of a checklist of all the things. So you need to learn what these things are so that you can use them in court to show the court if the other parent is engaging these things, but also to teach you what not to do. How to be a good parent. You're not going to do the things, okay, that are bad, okay. Understanding some of the laws. There's some basic laws that you can get, the Family Law Act, the Divorce Act in Canada, Child in View. So depending on your particular case and some of the situation, there are some specific references in these laws that you might find helpful. Like even the UN Convention on the Rights of the Child, which Canada is a signature to, and which is recognized in Canadian law, it recognized that a child has the right for a relationship with both parents. So, so there's a lot of things that can be, when you become familiar and learn about your rights, you can, in many cases, be much more effective than even a lawyer, when you take the time. Learn about the various dynamics, disorders. Again, we're getting into these various things. Parental alienation checklist, parental estrangement. Know what the difference between those is. Hostile aggressive parenting, refuse resist dynamics, which is quite common with alienating families where there's alienation going on. Understand about mental health issues, personality disorders such as narcissism. If you are in a case with a narcissist, you should be part of a education. You should be studying narcissism so that when you do go to court, you're able to point out these narcissistic behaviors, but also show the judge that you've taken some training. You've attended some workshops. You have studied some documents and done reading on narcissism, so that not only can you make that claim that the other parent may be a narcissist, but you've actually make that claim because you have studied it. Okay. And getting into domestic violence and parental alienation has become one of the most significant issues in family court disputes today. Okay. Kids are not seeing their parents, they're being denied access, and this is having tragic results. There's a couple advocates in there. I'm not quite sure who they are. Anybody know who they are? Anyways.
Hey, that's cool. Thanks. That's me and Wendy McDonald, Parents and Grandparents Peer Support Group in Burlington, Ontario.
Yeah. And basically, there have been protests all over in Canada about, again, the issue of alienation, where parents are destroying their children by trying to destroy the relationship between their child and the other parent. A lot of it with the complicity of the family courts and the lawyers who basically are trying to assist them, and people and other people and supporters who don't want to, they just want to support the alienator and they do not want to support the children. And as a result, we're running into a lot of problems with children. I actually spoke to just a father today, called me this morning. His son is 25 years old today, having mental disorders, can't function in society. And he said he spent $200,000 before his son was below the age of 16. He paid $200,000 in family court. And he said family court was responsible for what he believes is why his adult child now cannot function in society. And
yeah, I believe so too.
Yeah, and he's offered to do a video. I'm going to be doing a video of him, and I'll be making that video probably available, because this is what it's doing. This is what family courts are doing. So people need to get educated, by learning about the things that are going to harm children. You're also learning what not to do to harm children. Okay, right. Understand the issues involved and the solutions. So again, people just need to know, what are the solutions? Is a parent alienating? Are they trying to deny access? Does does the parent have mental health issue? Does the other parent, are they trying to get flying monkeys? Are they lying? Are they making false allegations? Basically, what you need to do is to learn what are the solutions to these things. Always trying to find a solution. Okay. Get connected to various community groups. These are people you need to link up with, other people who've gone through the system, people who can give you advice and give you tips where you're not paying a lawyer or psychologists or people to at sometimes hundreds of dollars per hour. So you can get support from many people in the community. It won't cost you anything. Parenting coaches, even if they're charging a bit of money or charging quite often, you're going to get more realistic help, and than even through a lawyer at a fraction of the cost. So parenting coaches are sometimes a good. Get linked up with various websites, Facebook pages, so you can actually ask people questions and to the same question that you're facing in your case. So it helps to get connected. There's an old saying, it takes a village to help a family or to raise a child. Well, absolutely. That's what's needed. Reach out to people in the community who can help you.
That's why we're here. So if people can come on and share their story or their solutions.
Yeah, basically what we're doing here is for people who are online or looking at this, going to look at this video, I'm giving them tips and some strategies. There's probably a lot more that can get into explaining each one of these. It could be a presentation sometimes for each one of these individually, but so I've just gone through a general list here but basically you have to learn how to deal with some of these family court professionals. There are a number of corrupt, there could be lawyers, psychologists, counselors, social workers, there are a number of them incompetent. They actually will harm children.
For
Child,
sure.
child protections and police. I've got a couple cases right now. The child protection workers, they are harming the children. Okay. Harming the children with their involvement. Okay.
They're making them say things that never happened. They're
Yeah.
making these kids, what is it, dissociate. They can't remember where they were when they're told to say these things,
Yeah. So,
right? So they can't fit their stories in place.
yeah, quite often child protection workers, and I have a case right now, the child protection worker has taken a position, a biased position against in favor of the mother. Okay. And I actually interviewed one of the children, and the 7-year-old child actually told me, and I have the video, I do not like the Children's Aid Society worker. She came into my school, took me out of class, and during this meeting, and they pulled the kids out of the class, they take them into a private room, and the little boy, and this was just a couple of weeks ago, and the little boy told me, the Children's Aid Society worker told me to lie and told me to keep secrets from my daddy. Those are his actual words from a 7-year-old boy. And of course, when I try to make contact with the Children's Aid, no response. Okay.
You
So
know,
this is the
Danny,
kind of stuff. These workers sometimes will implant memories into kids, but that's exactly the boy. I don't
yes,
trust them. I have a letter from I think it was a 14-year-old girl who described she thought that the worker was going to assault her. I have it right in her handwriting, and that she thought she was going to be assaulted right in at her school in a private room. And she said that the Children's Aid Society worker, and this is with the York Region Children's Aid Society worker, and I'm not afraid to say who it is because I've got her handwritten note, that the worker told her to lie and say that her father had hit her. So one of the big problems we have is that workers get a biased position, and they actually will help a child abuser actually hide the abuse, and the person and the parent who's trying to protect the child, they will actually get the protector out of the child's life. So same
yeah,
thing happens with children's lawyers. You can get the same thing. I've seen some horrible reports from children's lawyers, incompetent. I have reports that I've done forensic investigations on, incompetent, unaccountable, biased. I could go on and on and on about some of these workers with the children's lawyer's office. Okay.
right. You know,
Custody.
let me just say this. I was watching Oprah the other day, and Danny Broderick Jr. went on to the show with his sister. I don't know if you're familiar with the Broderick story where she killed the husband and the new wife during a custody dispute. But anyways, the boy was, I think, 16 or 17. He came on and said that they forced them to lie. The lawyers, the office of the lawyer, they forced him to lie about his mother. Right
Yeah.
on,
Now,
right on the Oprah show. And I'm thinking, that is so true. This is because when I went through my trial, my 31-year-old daughter said she didn't write that. The
yeah.
Office
Now,
of the
wait,
Children wrote it
I'm
18
only
years prior.
I'm only going to say, Mary, for the sake of time here, I want to keep moving along here.
Oh, we
But
got
again,
lots of time, Vernon. Don't worry about time.
well, we're up to an hour here, so
Yeah,
uh,
it's all
so again,
right. We're good.
children's lawyers can be a big problem.
Yes.
A lot of them are not registered social workers. You've got to be very careful. I have had kids tell me that they lie. I have a
Mm-hmm.
number of video recorded interviews with children because I do voice of the child interviews with kids. I have a number of videos in my library of children saying that they do not like their children's lawyer and
Right.
that they told them to lie. We
They
get the
need
same
to get rid
problem
of them.
with child custody assessors as well,
Right.
where and here's a couple things, ads right here. The ugly truth about child custody evaluations. Again, incompetence, lies, okay, bias, okay. There is so much corruption in the industry, and they charge like $15,000-$20,000 to do these things. Here's a quote from Dr. A psychologist here in Florida. There talks about, he says about the problem with them. Okay, they rely on these people just because they say we're a custody assessor, so the court kind of takes their word, and many times that they're biased and whatever. He talks about it, but there's horrible things. I've seen children harmed as a result. Okay, here it is, out of the Law Times magazine. This is for lawyers. Poor quality reports, prolonging custody battles. Okay, I got one with the Office of the Children's Lawyer right now. I have pulled it apart. It's so bad. And yet, when I tried to reach out to the worker who's involved, she won't even communicate with me when I'm only trying to help her improve her report. Okay, you have to educate kids about their rights and responsibilities. Again, their right to sometimes people are told, their parents, well, you can't show the kids your parenting agreement. You're going to get in trouble. You're not allowed to show them that. If a child is of an age and maturity to understand and can look at certain sections of their parenting plan that talks about, how they're going to do an exchange, or it's going to be every other week or whatever, as long as the child is of an age and maturity to understand, the law clearly states they have the right to know. You're not going to show them sections of your parenting or agreement where you talk about money and stuff like that. But when it comes to their parenting time, they have the right to be shown that. Okay. When I work out a parenting agreement, say for the summer or whatever for kids when they're off school, I actually have if the kids are old enough, there's actually a form that we have where the kids can actually acknowledge that they have read the parenting plan for the summer and that they support it. So if one parent's trying to put in a good parenting plan and the other one's is objecting, and the children really like this one and they're of an age of maturity, 12, 13, 14 years of age, then they can actually sign a document stating I've reviewed my summer parenting plan, I like it, and I want this. Okay, and of course I support that with a voice of the child interview where I go over those terms with the child. So, okay, get an advocate for your child if your child wants to speak up to be heard. So again, I do voice of the child interviews, and quite often, anything that parents quite often say that their child is saying is going to be discounted by the courts or by professionals, or parents are going to be accused of coaching their child. So if you want information from your child, and the child is of a maturity to understand some of the issues, and that child is willing to speak, then you should have that information conveyed through a third party, such as a child advocate, or like myself. What I do is I do voice of the child interviews. I interview them on video, okay, and so that the children will be heard. I even will help direct children where they can actually get affidavits. In Canada, in Ontario, a child 12 years of age has the lawful right to submit an affidavit into the family court. I've had situations where 13 and 14-year-old kids have had custody reversed immediately within 24 hours once they signed an affidavit, had it witnessed by a lawyer, and exposed the abuse that they were being subjected to by their custodial parent. And once the custodial parent and their lawyer realized that now the child has been video recorded, the child has now told, and what the child has said now has been put into a sworn affidavit witnessed by a lawyer. I have seen children within 24 hours, they are now living with the parent who's safe. And I've actually got letters from some of these children thanking me. I have signed letters from kids, saying, thank you, Mr. Beck, okay, for helping me get out of these horrible situations. So these are some of the things that people are told lawyers might tell people, oh, you can't get your kid to do an affidavit. BS. The law in this country, and it's called under the Canada Evidence Act, 12 years old, as long as the child is mature enough of a 12-year-old and can express their opinion and it understands what an affidavit is. And I usually explain that to kids, what it is. I give them examples. They look at examples from other kids. Once a child understands, they can go before a lawyer and with an affidavit and they can get it sworn. So these are some of the powerful things that people are discouraged from. Lawyers won't say anything because the lawyers are afraid that they're going to get in trouble from other lawyers and from the judge for getting a kid to do the affidavit. Okay. And you can't get the affidavit done by your lawyer. It has to be done by, a lawyer who's totally, that the child has gone to separately. So basically, get the tools you need to help in the fight for justice. We're talking about if you're going to fight, get yourself I usually recommend to people get an email account. You can get a Google or you can get a Microsoft account dedicated strictly for matters relating to court hearing. Just emails related to the other party, to lawyers, to the courts, everything. Keep it in one place, have a dedicated email, have some storage, usually Google and OneDrive, you can get some storage space. And sometimes what I do too is I will have access, or advocates actually will have access to people's G Drive or their OneDrive, and they can actually review their emails, help them write emails, help them review documents and things like that. So when you're getting help and you say, for instance, you have an advocate or a lawyer, you can actually give that those additional support persons access to your email account and to your file storage. Sometimes I will, when I'm working with somebody in educating them with some parenting education material, I will upload the files that they need to study into their Google Drive or onto their OneDrive, and that's what they're told, that you've got to read that and understand that. Okay, you should certainly get a computer. You can't be working off a phone. Okay, if you're going to be serious, certainly get Zoom because a lot of the stuff is going with video. Even court hearings now and conferences are Zoom. Make sure you got a way to scan documents. Although a lot of the documents coming from courts and from lawyers are already scanned.
Just so you know, Vernon, these phones are better than computers. They do more. Some computers you can't get programs to print, to type, to submit.
Well, again,
your phone will work better. Don't knock phones. I just got to tell you, don't knock a phone.
I'm going to politely disagree with you, Mary, because again, sometimes you're working on things where you need a screen where you can read things, and there are some apps that only are going to work on a computer. Now, I know that you certainly probably are more familiar with your phone, but for those who are more computer literate, in the end, working on Zoom and that, it's pretty difficult reading stuff off a phone, just like we were working on today. Anybody who's trying to read this document is going to have trouble on their phone. Okay?
But we can zoom up. We can zoom it.
Yeah. But
while
anyways,
you're talking.
Get the tools you need. Basically, just get yourself and a digital recording device because, again, people today still find they're being threatened. I had a call today, actually, where someone was threatened today involving the children, that borderline criminal offense. So people do have to make sure you can get a small digital recorder. They're very cheap, and whenever you're in the presence of potentially someone who might be using it against you, even police, when they come around, you want to record them, things like that, because
Absolutely.
You never know where you might be threatened. So proper tools.
Yeah.
Get the proper apps, applications, whatever you need to work. Keep an accurate journal of important dates. And so I tell everybody when they first call or whenever if they're going to work with an advocate, first thing that they should do is create a journal from going back as far as they can remember. When did these problems start? when were you denied access, when were you given bad emails, things like that, and to start building the evidence and to organizing the evidence. That's kind of a workshop in itself, how to go through and how to gather this stuff and how to organize it. I know that
Okay, we've gone over the hour now, Vernon, just so you know. Is there much more?
Okay, well, we'll moving on here. We'll cut off. You tell me when to cut off here.
Well, I'll give you another 5 minutes.
Okay, communicate via email. Okay, keep your communication civil. Okay, don't use text. Okay, with the other
What do you
party.
mean don't use text?
Do not text when you're dealing with the other party, with lawyers. Any communication relating to your family matter should be on email only.
Oh, okay.
Okay, it's better evidence. Make a list of those who will provide fair and support. If you got family members, gather together a family support network that can help you if you're doing what's fair and just. So there's even family members can actually even review documents or review a parenting plan and sign it. I know when I do a parenting plan for a parent, I actually will give them consent forms that they will take the parenting plan to their family support members. The family support members will read the parenting plan and will sign a document stating that they've read it and that they support it. Okay, if you're going to court, take witnesses in there. Okay, even if you're on Zoom, if it's a court hearing, have other people log into that Zoom conference, because all court hearings are public, even Zoom. Okay, again, learn how to effectively present yourself. Get a support group, a parent coordinator, a parenting coach. These are services that can help. Learn about unbundled legal services. Basically, learn how to represent yourself and just use lawyers for maybe certain areas that you really feel you need some extra confidence in. So, unbundled legal services. Learn about it. Okay. If there are any existing court orders agreements, make sure you comply with them unless there's unforeseen circumstances. Okay. I mean, if there's a hurricane or, there's 10 inches of snow, obviously you can't make exchange times or drop the kid off. Okay. But don't come up with silly excuses. Oh, I had a headache and I can't drop the kid off. Learn how to represent. You're in court as a self-represented litigant. That's going to save you a pile of money. There's
Education.
there's a whole organization by university professors and law professors who support this. Okay. Learn how to present an effective case. These are some of the points here. Never make false allegations, which you can be proven to be false.
Mm-hmm.
Okay. Make logical decisions. Keep calm. Another thing that helps, if you're, make sure you take photos to support the family who's with the kids, that you've got a good relationship. These can say a powerful relationship with your child and demonstrate to a judge, I'm a good parent. Like this, a picture like this right here, mother with the daughter. A judge looks at that and says, oh shit, looks like the kid's happy with mom. Okay. Okay. Show your support. Keep pictures. I think this is great, getting near the end here. Be an involved parent. If you're going to get custody or want custody, don't sit and let your kid go onto the YouTube and sit at home at night. Get involved with your kid. Help with homework.
Exactly.
Take them out. Play with them. Be active with your child so that you will be a real parent. Okay. Don't use the criminal charges against the other parent. It's only going to help destroy your child and make more trouble for you. And if there is minor forms of domestic violence, pushing, he yelled at me and I was scared, don't call the police or child protection. You're only going to make things a hell of a lot worse, not only for trying to sort things out, but for the kid as well. Okay. Make sure you understand what's in the best interest of the child and always act and do in accordance with that. And the last tip here, never give up in the pursuit of justice. Never, never give up. Okay. Learn, study, and if you follow a lot of these tips here, it'll help you from getting screwed over by the system and maybe losing your child and being alienated. So I think that's covers the document. We're
Well,
alone.
that is a mouthful there itself, Vernon. We really appreciate everything that you put up there. That's, it's good to know when you walk into a courtroom what to expect, what to do, how to act, how to behave, when to speak up. It's important because, the alienators are calm, cool, and collective only because they know they created all that mess, so they can't break down, and they know you're going to. So thank you again, Vernon.
Okay then.
I've got your email in the comment box for people to reach out to you. We did have someone ask if we could use this, and I did. If they can use the program now, and I believe they can, right?
Yeah, well, this isn't so much of a program; it's more or less tips and strategies.
Yes.
So
Yeah.
there are things that people can use. So
Okay.
it depends.
Good to know.
Yeah.
All right.
It
So
boils
thank
down
you
to,
again.
there's an old phrase: knowledge is power,
Yeah,
and people just have to invest in time to achieve justice for themselves. That's what it
that's
boils down
right. That's right. So today is Tuesday. Let me just check and see who we have on Thursday. We have Sarah Taylor at 1 p.m. on Thursday, this coming Thursday. So tune in this Thursday as well for another program on Let's Talk, Real Talk on parental alienation and family domestic violence. Thanks again, Vernon. Alienated parents, grandparents, alienated children. Don't give up. Never give up on your family. Professionals out there, if you want to share your knowledge, your education, and everything, please PM me and we will get you on the program as well. Andy Martens sends his regards. He had to take his wife to treatment, so he couldn't stay the whole time. So thanks again, everyone, and you have a pleasant afternoon.
to. Okay, bye bye.